The Subcommittee on Immigration and Border Security, this is a hearing on birthright citizenship. Is it the right policy for America? And I would say at the outset to my colleagues and to our witnesses, I have a meeting that is going to regrettably take me away, so at some point I'm going to turn the gavel over, but I want to thank you because I won't be here at the end. Thank you for participating in this, and thank my colleagues as well. The Subcommittee on Immigration and Border Security will come to order without objection. The chair is authorized to declare recesses of the committee at any time. We welcome everyone, and the other administrative note is we are expecting votes in the not-too-distant future, so we will need to go vote, and then the members that are able to do so would then come back, and we apologize in advance for any inconvenience, but there's no way to avoid that. At this point, I will recognize myself for an opening statement, only to say that this is an interesting and important topic. And with that, I will yield to the gentleman from Iowa, Mr. King.
Thank you, Mr. Chairman. I appreciate you yielding for the purposes of this opening statement. And I would like to raise these points at the beginning of this hearing, that this topic of birthright citizenship is something that I have worked on for some time. I want to give some credit to now Governor of Georgia, Nathan Deal, who used to be the one that was leading on this topic, and when he went back to Georgia, somebody had to pick up the ball and go with it. It's myself in the House, primarily with a lot of colleagues working together, and also Senator Vitter on the other side is leading on a very similar bill that I'm speaking to, and not exactly that it is a component of the subject here that's before us. And the 14th Amendment of the Constitution says that all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States and the state where they reside. And that little troublesome clause in there, subject to the jurisdiction thereof, is the subject of our discussion here in this hearing today, and the policies that flow from it. And for those who argue that the physical birth of a baby on U.S. soil is an automatic grant of citizenship by policy, by constitution, by statute, I believe they're uttering an ungrounded statement in that clause, that troublesome clause of subject to the jurisdiction thereof, defined it differently for clear reasons. And that is that if I look at the quotes from a number of U.S. senators who debated this topic back in 1865 and 66. The 14th Amendment was ratified finally in 1868. The lead senator on this, one of the authors, Senator Jacob Howard, said this: "This will not, of course, include persons born in the United States who are foreigners, who are aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons." And the purpose, of course, of the 14th Amendment was to guarantee that the babies born to the freed slaves would be citizens of the United States. The specificity in the clause was debated fairly thoroughly in the United States Congress, and it was there because there were Native Americans, called Indians under the statute then and the amendments then, who would lose their membership in the tribe if they were granted automatic citizenship. So the clause was carefully targeted to make sure that African American babies born in America were citizens, just as those newly freed slaves became citizens under the 13th Amendment of the Constitution. It did not contemplate that anyone who could sneak into the United States and have a baby would be conferred automatic citizenship on that baby. That's a practice that has evolved, not a law that has been passed, not a provision within the Constitution anywhere, including in the 14th Amendment. So we'll get deeper into this definition of the subject to the jurisdiction thereof. This will be, if this bill is passed and becomes law, I don't think there's any doubt it'll be litigated. I look forward to that litigation. I think an objective court that would review the documents that build to this point has to conclude the same thing that I have. This is also something that flows from the Dred Scott decision that said that African Americans could never be citizens in the United States. That's the biggest reason that. Well, it's one of the two big reasons for the Civil War. It's still debatable as to which is the biggest reason, I might point out. But it's the reason for the 13th Amendment and the 14th Amendment to correct Dred Scott. And so it corrected it, and then we started this practice. So and to protect Native Americans. So the illegal parents, are they going to decide? Or are we going to decide as representatives of the people of the United States of America? And I suggest that it's our job here in this Congress to decide who will be citizens, not someone in a foreign country that can sneak into the United States and have a baby and then go home with a birth certificate. By the way, birth tourism has grown substantially. We had a hearing on this some years ago. The turnkey price for a Chinese pregnant woman to fly to the United States and check into a hotel, go through the maternity process, have a baby, get the birth certificate, take the baby back to China was $30,000. And that testimony several years ago, that price has gone up to $40,000 to $80,000. However, they still attest that they can't pay for the medical bills, and so we, the taxpayers, fund that. Also, the numbers of birth tourism were then 340,000 to 750,000. That's by recollection from that testimony. And today I think we're going to hear maybe 300 to 400,000 babies born automatically in America. There's a lot of data to flow out here. The objective thing for us to do is set the policy like almost every other industrialized country in the world has done. I encourage that we do that. I thank the chairman. I yield back the balance of my time.
Thank the gentleman from Iowa. The chair would now recognize the gentlelady from California, Ms. Lofgren, for her opening statement.
Thank you, Mr. Chairman. Earlier this month, the House Committee on Science, Space, and Technology, where I also serve, held a hearing to cast doubt on global warming science. Never mind the overwhelming consensus in the scientific community that humans are contributing to climate change. Never mind the evidence that rapidly increasing greenhouse gas emissions are disrupting life all over the world. Rather than working to develop and support innovative methods of combating climate change, the Science Committee held another hearing to debate whether established science is real. I can't help but think that today's hearing is a similarly fruitless effort. The question that we're asked to consider is whether birthright citizenship is the right policy for America. I think the answer is clearly yes, and that in fact no other policy would be worthy of this country. The origins of birthright citizenship long predate the 14th Amendment. Supreme Court Justice Joseph Story said early on that, quote, nothing is better settled at common law than the doctrine of jus soli, or citizenship by place of birth. The Supreme Court once diverged from this principle in the infamous Dred Scott decision when it denied birthright citizenship to the descendants of slaves. The violent institution of slavery itself was clearly an incredible injustice. In Dred Scott, the Supreme Court found a way to continue that injustice, to reinforce the caste system at the heart of slavery, even with respect to children born in this country to freed slaves. There's no question that the 14th Amendment was adopted and the Citizenship Clause was included as the very first sentence of that amendment to repudiate Dred Scott and to help us turn the corner of an ugly chapter in our nation's history. But the clause did not simply say, as it could have, that children born in this country to freed slaves are citizens of this country. Rather, the framers of the 14th Amendment spoke in general terms, guaranteeing that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. From the debate in Congress at the time, it's clear that they understood this language to have much broader reach. It's also clear that members were motivated to embed this language in the Constitution precisely because a constitutional right of citizenship would be protected from the caprice of Congress and the prejudices of the day. 30 years after the 14th Amendment was ratified, the Supreme Court had occasion to consider whether a child born in this country to Chinese immigrants who were by law prohibited from naturalizing was entitled to birthright citizenship. The Supreme Court answered the question in the affirmative with sweeping language that's worth quoting. The court held, quote, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications, as old as the rule itself, of children of foreign sovereigns or their ministers, or born on foreign public ships, or of the enemies within and during a hostile occupation of part of our territory, and with the single additional exception of children of members of Indian tribes owing direct allegiance to their several tribes. A minority view among legal scholars holds that Wim Kim Ark speaks only to children of legally present immigrants. The language in the case certainly does not suggest that additional exceptions or qualifications to the fundamental rule of birthright citizenship would apply to children of undocumented immigrants born in this country. But even if that were true, the Supreme Court in the 1982 case of Plyler v. Doe settled the question. In Plyler, the court explained that the phrase subject to the jurisdiction in the Citizenship Clause applies as comprehensively as the phrase within its jurisdiction in the Equal Protection Clause, and that no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful. So if there really isn't a serious debate among scholars about what the clause means, is the purpose of this hearing really to consider whether the Citizenship Clause of the 14th Amendment, adopted in the aftermath of the Civil War, has outlived its usefulness? Can we expect the full committee to soon take up the question of whether the Equal Protection Clause guarantees too much equality? Preparing for this hearing, I thought about the Republican Party's history as the party of Lincoln. On the GOP's own website, there is a history of the party that proudly marks January 13, 1866, as the day that the 14th Amendment was passed by Congress, quote, with unanimous Republican support and against intense Democratic opposition, unquote. And yet the question we are asked to consider today is whether the passage of the 14th Amendment and the Citizenship Clause almost 150 years ago was good policy for America. It's no wonder that when this issue flared up last in 2010 and congressional Republicans voiced their support for legislation and a constitutional amendment to restrict birthright citizenship, prominent Republicans like Mark McKinnon cautioned that, quote, the 14th Amendment is a great legacy of the Republican Party. It is a shame and an embarrassment that the GOP now wants to amend it for starkly political reasons. Republican leaders in the Senate narrowly avoided debate on this topic just last week when they prevented Senator Vitter from offering a birthright citizenship amendment to a bill on human trafficking. I cannot imagine that Republican leaders in the House are any more interested in bringing this issue to the floor. Actually, it's been 10 years since the subcommittee last held a hearing on this topic, and I note that one of our witnesses, Professor Eastman, testified before us at that time. Hopefully, all of that means that this will be the last we hear of this issue for quite some time. And with that, Mr. Chairman, I would like to ask unanimous consent to place in the record a testimony from the Community Relations Council of the Jewish Federation of Silicon Valley, as well as statements from the Leadership Conference on Civil and Human Rights, the American Civil Liberties Union, First Focus Campaign for Children, the National Association of Latino Elected and Appointed Officials, the League of United Latin American Citizens, the Constitutional Accountability Center, Church World Service, Lutheran Immigration and Refugee Services, American Immigration Council, a sign-on letter from 14 national Jewish organizations, the Jewish Council for Public Affairs, Franciscan Action Network, Asian Americans Advancing Justice, American Immigration Lawyers Association, National Council of Asian Pacific Americans, the National Latina Institute for Reproductive Health, the National Immigration Forum, We Belong Together, the Coalition for Humane Immigrant Rights of Los Angeles, and OCA, the Asian Pacific American Advocates.
Without objection. I thank the gentlelady. The chair will now recognize the gentleman from Virginia, the chairman of the full committee, Mr. Goodlatte.
Thank you, Mr. Chairman. I rarely have a conversation about general immigration policy in which the issue of birthright citizenship is not raised. Yet, it has been several years, nearly 10, I believe, since this subcommittee has looked at the issue. So I thank the gentleman from South Carolina for holding this hearing. The discussion is important as we move forward with any reforms to immigration law and policy. Birthright citizenship is the principle that the place of an individual's birth automatically determines that individual's citizenship. The U.S. policy on birthright citizenship stems from the 14th Amendment to the U.S. Constitution, of which the Citizenship Clause states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. Congress subsequently included that language in statute. However, As we will hear today, the phrase subject to the jurisdiction thereof is central to the debate over whether the U.S. Constitution requires that the U.S. adhere to birthright citizenship. It is central to the question of whether the U.S.-born children of unlawful aliens should be considered citizens at birth. A close look at and discussion of the legislative history of the 14th Amendment, the language of the Civil Rights Act of 1866, and relevant case law like Elk versus Wilkins and United States versus Wong Kim Ark are central to determining the meaning of subject to the jurisdiction thereof. The question of whether our forefathers meant for birthright citizenship in all circumstances to be the law of the land is far from settled. In any event, we must still determine if it is the right policy for America today. Very few countries with advanced economies have a policy of birthright citizenship. In fact, of the G20 countries, only the United States, Canada, and Mexico automatically grant citizenship based on the individual being born in the country despite the citizenship or immigration status of the parents. That is not to say that just because other countries do not have a certain policy or law, the U.S. should not have that policy or law. But as members of Congress, we should have an open and honest discussion about the consequences of automatic birthright citizenship. Evidence suggests that automatic birthright citizenship incentivizes illegal immigration and abuse of U.S. immigration law and policy. And extremely troubling is the rise of the birth tourism phenomenon in which pregnant women from foreign countries briefly come to the U.S. specifically to give birth here so that their children become U.S. citizens. The women and children then return to their home countries. This has become a multi-million-dollar business in certain areas of the U.S. where maternity hotels advertise in foreign countries to house pregnant foreign nationals in the U.S. until they give birth. Even if you believe that birthright citizenship is the right policy for the United States, and I do not, but even if you do, such abuse of our generous policy is unacceptable. I look forward to the witness testimony and the discussion of whether and how to change the U.S. birthright citizenship policy, and I yield back. Thank you, Mr. Chairman.
Chair, thanks to the gentleman from Virginia. Without objection, other members' opening statements will be made part of the record. We have a distinguished panel before us, and I will begin by swearing you in, and then I will introduce you en banc, and then recognize you individually. So if you would, please stand and raise your right hand. Do you swear the testimony you're about to give is truth, whole truth, nothing but truth, so help you God? May the record reflect all witnesses answered in the affirmative. We'll start with Dr. John Eastman. He's the founding director of the Constitutional Jurisprudence Clinic, a public interest law firm affiliated with the Claremont Institute. He also serves as the Henry Salvatore Professor of Law and Community Service at Chapman University Fowler School of Law, and also served as the school's dean from 2007 to 2010. Prior to joining the Fowler School of Law faculty, he served as law clerk for Justice Clarence Thomas at the United States Supreme Court and Judge Michael Ludig at the United States Court of Appeals in the Fourth Circuit. He earned his JD from the University of Chicago Law School, where he graduated with high honors. Next after him will be Professor Lino Graglia, and if I mispronounce anyone's name, forgive me. Professor Graglia serves as the A.W. Walker Centennial Chair in Law at the University of Texas at Austin School of Law, has been a visiting professor at the University of Virginia School of Law. He's written widely in constitutional law, especially on judicial review, constitutional interpretation, race discrimination, and affirmative action, and also teaches and writes in the area of antitrust law. He received his JD and LLB from Columbia University School of Law, where he served as editor of the Law Review, and his BS in economics and political science from the City College of New York. After him will be Mr. John Feary. He currently serves as legal policy analyst with the Center for Immigration Studies. His editorials have appeared in various publications, including U.S. News and World Report and the Washington Times. He received his BA in Political Science and Communications from the University of California, Davis, and his JD from American University's Washington College of Law. While in law school, he worked on this very subcommittee, which was then known as the Subcommittee on Immigration, Border Security, and Claims. And finally, Mr. Richard Cohen currently serves as the president of Southern Poverty Law Center, where he has worked since 1986 when he joined their staff as its legal director. In this position, Mr. Cohen has litigated a wide variety of important civil rights actions, defending the rights of prisoners to be treated humanely and working for equal educational opportunities for all children. He's a graduate of Columbia University and received his JD from the University of Virginia School of Law. Welcome to each of you. The lights mean the same thing they mean traditionally in life: green, go; yellow, speed up; red, go ahead and conclude that thought if you would. Dr. Eastman.
Thank you, Mr. Chairman, and all the members of the committee, and I'm particularly delighted to be here again. I worked closely with now Governor Deal when he was here, and I'm so happy, Representative King, that you're taking up the charge. I think this is an extremely important issue. Congress has the power over naturalization. It's a plenary power, and that means you get to set the policy of how large or small, how unrestrained or restrained our immigration into this country is going to be. The founders did that by design because it's an inherently political question. The question for us is whether one of the three great magnets to violating or ignoring the policy you set out can be addressed by statute, or whether it requires a constitutional amendment. Those three magnets are, of course, an opportunity for a job, employment, access to our huge welfare benefits, and access to the holy grail of American citizenship. Both members that talked about the Constitution's 14th Amendment rightly focused on the phrase subject to the jurisdiction. If that phrase is not to be entirely redundant, it has to mean something other than being born on U.S. soil. And that something is allegiance. And I think if you look at the debates in Congress, if you look at the language of the 1866 Civil Rights Act, if you look at the first couple of Supreme Court cases to address this issue, and the legal commentators, including the most prominent one at the time, Thomas Cooley, they all recognized that the subject to the jurisdiction clause meant allegiance owing. There were two kinds of jurisdiction that was recognized in international law at the time. One they called mere partial or territorial. The other they called complete or whole jurisdiction. And it's the latter that the 14th Amendment refers to. The best way I can describe this is to imagine a foreign national, say from Great Britain, who comes to visit the United States as a tourist. When he's here, he's subject to our laws. He drives on the right side of the road rather than the left side of the road as he does at home. But that does not make him subject to our other jurisdiction. He doesn't become a citizen. He doesn't participate in our political process. He can't be tried for treason if he takes up arms against us, although taking up arms would be subject him to other recourse. It's that lack of allegiance that makes him not subject to the jurisdiction in the full and complete sense that was envisioned by the 14th Amendment. And so, too, today, there are people who are here lawfully and permanently who we have recognized as having some extent of allegiance to the United States, and their children will be deemed automatic citizens by virtue of this 14th Amendment. That was the holding and the full extent of the holding of the Wong Kim Ark case in 1898. Mr. Wong Kim Ark was a child of lawful permanent residence in the United States who had done everything we allowed them to do to demonstrate their allegiance to the United States. They were not here on tourist visas. They were not here as temporary sojourners, to use the language of the day. They were here permanently, had taken up domicile as well as residence in the United States. And the language that Representative Lofgren quoted from that case, there was a particular phrase in it that she said, in the allegiance of the United States, the court held. That meant it fit within the language of the 14th Amendment in a way that temporary visitors here, temporary visitors who may have come here legally and then overstayed their visa and were now here illegally, and certainly temporary visitors who were never here legally in the first place, who never had been granted the consent of the United States to be here, who owed no allegiance to the United States and in fact continue to owe allegiance to their home country. Their children, through them, owe allegiance to the home country, not to the United States, and are therefore not subject to the jurisdiction in that full sense. That is not only what the Constitution sets out and requires, but it is phenomenally good policy, because otherwise the fundamental break we made with the old feudal system, that if you were born on the sovereign soil, you shall forevermore be a subject of that sovereign. The fundamental break we made with that idea in the Declaration of Independence is we form a body politic by mutual consent. If we are to accept this newfound version of birthright citizenship, that no matter how you get here, how little you have obtained consent for being here, you can demand automatic citizenship, blows a hole through that notion of consent of the governed. And until we get back to the Declaration's understanding of consent, that's what creates citizens and what creates a people and a body politic, you will never be able to have any limitations on our immigration policy at all. I think the various bills that have been proposed over the years clarify that that constitutional language creates a floor, and how far above that floor we want to go is a matter of policy judgment for the Congress. I would suggest one thing. We have, for the last 40 or 50 years, adopted the notion, piecemeal and by osmosis almost, that mere birth on U.S. soil is enough. And a lot of people have come to rely on that. So you might say, let's get this fixed and clarified going forward. But for those people over the last 50 years who have relied on it, let's grant them citizenship as well retroactively, but let's make clear that that grant of citizenship is pursuant to Congress's naturalization powers, not because it's mandated by the 14th Amendment. And I think if you do that, you will put on this body on very clear record of what your understanding of the constitutional floor is. Thank you very much, Mr. Chairman.
Thank you, Dr. Eastman. Professor Graglia.
I'm glad to have this opportunity to speak to this important question, though I'm not sure I can add much to what Professor Eastman's very thorough presentation did. It is difficult to imagine a more irrational and self-defeating legal system than one that makes unauthorized entry into the country a criminal offense and simultaneously provides the greatest possible inducement to a legal entry, a grant of American citizenship. How could such a legal system have come to be and be permitted to continue? The answer, its defenders will tell you, is the Constitution. As Robert Jackson said in response to such arguments, the Constitution is not a suicide pact. The basis of the constitutional claim of birthright citizenship is, of course, the Citizenship Clause of the 14th Amendment, which has been read many times. Not everyone born in the United States, therefore, is automatically a citizen. Only those subject to the jurisdiction of the United States. So the question becomes, what does that jurisdictional statement mean? How should it be interpreted? Like any writing, or at least any law, it should be interpreted to mean what it was intended to mean by those who adopted it, the ratifiers of the 14th Amendment. They could not have meant to grant birthright citizenship to children of illegal aliens because, for one thing, there were no illegal aliens in 1868, because there were no restrictions on immigration. The purpose of the 14th Amendment was to constitutionalize the great 1866 Civil Rights Act, our first civil rights statute, which begins with the statement from which the Citizenship Clause of the 14th Amendment is derived. And that statement is, all persons born in the United States and not subject to any foreign power are hereby declared to be citizens of the United States. The phrase, not subject to any foreign power, would clearly exclude the children of resident aliens, legal as well as illegal. The 14th Amendment Citizenship Clause substitutes the phrase, and subject to the jurisdiction thereof, but there is no indication of any intent to change the original meaning. Senators Lyman Trumbull of Illinois and Howard of Ohio, principal authors of the Citizenship Clause in both the 1866 Act and the 14th Amendment, both stated that subject to the jurisdiction of the United States means not owing allegiance to anybody else, which again seems to clearly preclude birthright citizenship for the children of legal resident aliens and, a fortiori, more so, of illegal aliens. It appears, therefore, that the Constitution, far from requiring the grant of birthright citizenship to the children of illegal aliens, is better understood as denying that grant. Excuse me. In the 1873 Slaughterhouse case, the Supreme Court stated in dicta that the phrase, subject to the jurisdiction thereof, was intended to exclude from birthright citizenship children of ministers, councils, and citizens or subjects of foreign states born within the United States. In 1884, in Elk v. Wilkins, the court held that a child born to members of an Indian tribe did not have birthright citizenship because although born in the United States, it was not, quote, subject to the jurisdiction thereof. No one, the court said, can become a citizen of a nation without its consent, and there cannot be a more total or forceful denial of consent to a person's citizenship than to make that person's presence in the nation illegal. In 1898, however, the court held in U.S. v. Wong Kim Ark that the Citizenship Clause granted birthright citizenship to children born in the United States of legal resident aliens. Two dissenting justices argued correctly that, quote, the rule making the locality of birth the criterion of citizenship is based on ancient English common law that did not survive the American Revolution, unquote. Every European country, including Great Britain now, has rejected that rule. Whatever the merits or lack of merit of Wong Kim Ark as to children of legal residents, it does not settle the question of birthright citizenship as to children of illegal residents or children born of legally admitted aliens who have overstayed their visa. In 1982, however, in Plyler v. Doe, which was mentioned, a 5-4 decision, the court, in a footnote, interpreted Wong Kim Ark as holding that, quote, no plausible distinction can be made between legal and illegal resident aliens. That statement cannot settle the matter, however, because it is not only a dictum, had nothing to do with the case, but was based on a clearly mistaken understanding of Wong Kim Ark. The apparent general assumption that the children of illegal aliens have birthright citizenship as a constitutional right is therefore clearly subject to challenge. A recent scholarly study of the issue concluded the framers of the Citizenship Clause had no intention of establishing a universal rule of birthright citizenship, and Congress has the authority to reject that rule. Judge Richard Posner.
Professor, I don't want to interrupt you. If you could maybe conclude. I hate to interrupt law professors.
Conclude that Judge Richard Posner, one of the most influential justices of the country, agreed. Congress, he said, should rethink awarding citizenship to everyone in the United States, including children of illegal immigrants whose only chance is to come here. In my opinion, a law ending birthright citizenship for the children of illegal aliens should and likely would survive constitutional challenge. Thank you.
Thank you. Thank you, Professor. Now, Mr. Feary.
Thank you, Chairman Gowdy, Ranking Member Lofgren, and the distinguished members of the subcommittee for allowing me to speak before you today on the very interesting issue of birthright citizenship. Every year, approximately 350,000 to 400,000 children are born to illegal immigrants in the United States. To put this in perspective, this means that 1 out of 10 births in the U.S. is to an illegal immigrant mother. The executive branch automatically recognizes these children as U.S. citizens, despite the foreign citizenship and illegal status of the parent. And because the executive branch automatically recognizes them as U.S. citizens, they provide them Social Security numbers and U.S. passports. The same is true of children born to tourists and other aliens who are in the country in a legal status, but in a temporary status. It is unlikely that Congress intended such a broad application of the 14th Amendment Citizenship Clause, and the Supreme Court has only held that children born to citizens or permanently domiciled immigrants must be considered U.S. citizens at birth. Some clarity from Congress would be helpful in resolving this ongoing debate. In recent decades, the issue has garnered increased attention for a number of reasons. First is the mass illegal immigration this country has experienced. The population of U.S.-born children with illegal alien parents has expanded rapidly in recent years, from 2.7 million in 2003 to 4.5 million by 2010. Under the immigration enforcement priorities of the Obama administration, illegal immigrants who give birth to U.S. citizens have become low priorities for deportation. Furthermore, the President's DAPA program, the Deferred Action for Parents of Americans and Lawful Permanent Residents program, a program currently held up in the courts, would provide benefits to illegal immigrants who give birth here and allow them to, quote, stay in the U.S. without fear of deportation, end quote. That's from the administration. The broad interpretation of the Citizenship Clause forms the basis for these policies. Second is the issue of chain migration. A child born to illegal aliens in the United States can initiate a chain of immigration when he reaches the age of 18, and he can sponsor an overseas spouse and unmarried children of his own. When he turns 21, he can also sponsor his parents and any brothers or sisters. Approximately 2/3 of our annual immigration flow is family-based, and that's part of the reason, not the entire reason, but part of it. And this number continues to rise every year because of the ever-expanding migration chains that operate independently of any economic downturn or labor need. Third, the relatively modern phenomenon of affordable international travel and tourism has increased the opportunity for non-citizens to give birth here, raising questions about the appropriate scope of the Citizenship Clause. According to the Department of Homeland Security, in 2013, there were 173 million non-immigrant admissions to the United States. This includes people entering for tourism, business travel, and other reasons, but it also includes those who are engaging in birth tourism, which is a growing phenomenon that has arisen in direct response to our government's broad application of the Citizenship Clause. Birth tourism is a practice of people around the world traveling to the United States to give birth for the specific purpose of adding a U.S. passport holder to the family, while misrepresenting the true intention of their visit to the United States. An entire birth tourism industry has been created, and the phenomenon has grown largely without any debate in Congress or the consent of the American people. Birth tourism is becoming much more common with every passing year, and I do think at some point Congress will have to address it. Fourth is the sense among many Americans that the United States is falling behind the global trend on birthright citizenship, as many countries which once had such policies have ended them in recent years. The United States and Canada are the only two advanced economies, as rated by the IMF, to grant automatic citizenship to children of illegal aliens. For these reasons and others, there has been a bipartisan effort to end birthright citizenship legislatively, here, even in Canada as well. Multiple legislative efforts to clarify the appropriate scope of the Citizenship Clause have been proposed by both Republican and Democrat politicians, as there remains much debate about who should be considered subject to the jurisdiction of the United States. In 1993, Senator Harry Reid, Democrat from Nevada, introduced legislation that would limit birthright citizenship to the children of U.S. citizens and legally resident aliens. And similar bills have been introduced by other legislators in nearly every Congress since, I believe. Some clarification from Congress on this issue would certainly be welcomed and perfectly appropriate. I'd be happy to take questions on these and other issues. Thank you.
Thank you, Mr. Ferry. They have called votes, but Mr. Cohen, I'm going to let you give your opening, and then we will recess for votes after that. Mr. Cohen.
Thank you, sir. It's an honor, a great honor to be here today. Birthright citizenship is a core value enshrined in the first sentence of the 14th Amendment. With the exception of children of diplomats, members of Indian tribes, and hostile enemy occupiers, the Birthright Citizenship Clause provides that all children born in this country are citizens entitled to the full blessings of our democracy. The immigration status of their parents is irrelevant. The view of birthright citizenship that I've just expressed is compelled by the plain language of the 14th Amendment, by its legislative history, and by Supreme Court precedent. Those offering a contrary view must bear a heavy burden of persuasion. The Birthright Citizenship Clause, as a number of you have noted, provides that all persons born or naturalized into the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. On its face, the clause makes no distinction on the basis of one's parents' immigration status. From a commonsensical point of view, children born in this country are subject to the jurisdiction of the state. They must obey our laws, they must pay taxes if they earn income, they can be jailed or removed from their homes and placed in foster homes. As Professor Graglia noted, Plyler adopted this commonsensical view, although he apparently believes it's wrong. In the seminal case of Wong King Arp, the Supreme Court made it clear that the blessings of birthright citizenship do not turn on the immigration status of one's parents. As the committee knows, the case concerned the status of someone born in this country to Chinese parents. Under the law at the time, his parents were ineligible for citizenship. The court pointedly noted that the parents were subjects of the Emperor of China. Nevertheless, the court ruled that Wong Kim was subject to the jurisdiction of this country under the 14th Amendment and therefore a citizen by virtue of having been born here. The legislative history of the 14th Amendment powerfully supports this understanding. During the debate of the proposed amendment in the Senate, Senator Cowan focused on gypsies in an effort to persuade his colleagues not to support birthright citizenship. He described gypsies as pariahs. He said that, and this is a quote, they were trespassers wherever they go. Trespassers. That's about as close as it gets in 1866 to so-called illegal immigrants. No one in the Senate took issue with Senator Cowan's stereotypic description of gypsies. No one claimed that they were not trespassers. But what other senators did make clear was that the Birthright Citizenship Clause would confer citizenship on the children of gypsies. The Supreme Court in Wong Kim Ark took note of this fact. The Wong Kim Court emphasized that the 14th Amendment's grant of birthright citizenship is very broad. The court also emphasized that while Congress may have plenary authority over immigration, including the authority to legislate against those who are unpopular, it is powerless to limit birthright citizenship by ordinary legislation. The only way that that can be done is by constitutional amendment. That is the course that those who oppose birthright citizenship must pursue. Let me use one of our cases to illustrate why I hope that those who want to change the law are not going to be successful. Recently, we had the privilege of representing a young woman named Wendy Ruiz. She was born in Florida and lived there all her life. Yet the state was denying her the possibility of in-state tuition because she couldn't prove that her parents were here legally. We sued and won the case, and the court, citing Plyler, emphasized that we shouldn't visit the supposed sins of the parents on their children. Last fall, after attending college, Wendy spoke at the Dexter Avenue Baptist Church. That's the church from which Dr. King and his allies launched the modern civil rights movement. She told a deeply, deeply American story. She talked about the struggles of her farm worker parents. She talked about her determination to get an education. She talked about her dream of becoming a lawyer so she could give back to the community. One day, I hope that she gets to testify before this committee. It is simply inconceivable to me that our country would deny the blessings of citizenship to the Wendy Ruizes of the world. Our immigration system may be broken, but we should resist the calls to roll back the constitutional guarantee of birthright citizenship in an effort to fix it. The clause expresses a fundamental principle of our democracy, that there are no second-class citizens, that all persons born in this country, regardless of the status of their parents, are equal citizens under the law. I appreciate it, Mr. Chairman. Look forward to your questions.
Thank you, Mr. Cohen. We will recess or adjourn briefly to go vote, and then we'll all come back, and we thank you for your patience while we're gone. The the committee will come to order. Thank our witnesses for your patience as we went to vote, and I will ask my questions, and then I will turn it over to Congressman King, and then he'll recognize Congresswoman Lofgren. But I want to start by saying to all of them, but in particular, I have the openings of Mr. Cohen and Mr. Eastman in mind. And I was talking to a colleague on the way to votes about what an interesting, perhaps even fascinating legal argument it is, and the way that you both approach the law. And there was no demagoguery, and there were no personal attacks, and nobody suggested that anybody loved the country more or less than the other. And I want to compliment all four of you for your openings, but Dr. Eastman and Mr. Cohen, in particular, those of us who like the law and are fascinated by the law, it is a legal inquiry to me. So against that backdrop, Mr. Cohen, as I read the 14th Amendment and the conjunctive and, all persons born and subject to the jurisdiction, do you assign meaning to the phrase subject to the jurisdiction? And if so, what meaning do you assign to it?
Of course I do. And I would assign it the meaning that the court gave in both Wong Kim Ark and in Plyler. It has predominantly a geographic meaning, and the court in Plyler was unanimous in that regard. There's another aspect to it, and that is that we know that subject to the jurisdiction excluded persons who were the children of foreign diplomats. It excluded members of Indian tribes that had been recognized, and it also included what were called hostile enemy combatants, or alien enemies in hostile occupation of the country. Those were the three groups that the language excluded.
And Dr. Eastman, what would you do with Mr. Cohen's analysis, and how would yours be different?
Well, I think it does that, but it also does much more. And the reason the Indian example is so important, and the Supreme Court's holding in Elk versus Wilkins in 1884 is so important, is they were neither ambassadors and they were not foreign invaders occupying our territory. They were born in the United States, but the Supreme Court held that they did not owe allegiance to the United States because they owed allegiance to another power. And it's that question, do you owe allegiance to another power, which those who are here visiting temporarily on tourist visas or temporary work or student visas, and particularly those who are only here illegally, continue to owe allegiance to a foreign power and therefore are not subject to the jurisdiction in that broader sense. And to read that clause as narrowly as Mr. Cohen does, as the dicta in Wong Kim Ark did, as the footnote in Plyler versus Doe, and is not a holding at all in that case, I think is to make that clause largely redundant. The main force it would do under that view is to to exclude the children of ambassadors. But they are already considered not born in the United States because of the fiction of extraterritoriality, that, the sovereignty of the ambassador follows him wherever he goes. And so it doesn't even do any work on that thing. All of the original understanding, the debates in the 14th Amendment, the early Supreme Court cases and what have you, all added this allegiance piece, that it was subject to the complete jurisdiction, not what we called the mere territorial or partial jurisdiction.
I was somewhat critical. I think it was the Roper case where the Supreme Court relied upon what other countries are doing in the area of capital punishment. I think it was Roper versus Simmons, if I'm not mistaken. So it's a little disingenuous for me to cite what other countries are doing as a reason for us to do it. So I'm not doing that. I'm simply asking, why did the other countries, to the extent they've changed their citizenship policy, what informed and instructed the changes that they went through?
Mr. Fuhrer may have a broader answer than I do. My suspicion is that they recognized that automatic citizenship was a powerful magnet to avoid the immigration laws of the country. It's not as powerful as the welfare state, and it's not as powerful as the employment magnet. I'll concede that, but it is the third most powerful one. And if you're going to have, as I testified at the beginning, if you're going to have anything other than just a free, open border, if you're going to have rules about lawful immigration, you have to address those magnets. And I don't think our Constitution compels that we address it in the way we have, and that's the big fight.
Mr. Fury, I'll give you a couple of minutes, and then I want to give Mr. Cohen a chance to finish up, and then I'll be out of time.
Yeah, the research I looked at in terms of what other countries are doing on birthright citizenship, I was able to conclude, dealing with other government officials, looking at their constitutions, that about 30 of the world's 194 countries do grant automatic citizenship to children of illegal aliens. As I mentioned earlier, only 2 advanced economies in the world, the United States and Canada, have that practice. And the truth is, when you start to look at these other countries that claim to have it, it comes with exceptions. You know, there are certain countries that say, yeah, we welcome citizenship for everyone, but you look at their actual population, you discover that 45% of their population is made up of indigenous people who have no right to citizenship. You discover that some of these countries are very quick to enforce their immigration laws and never actually end up giving grants to children of illegal immigrants. Mexico, for example, tells me they're not aware of any situation where that's actually happened, even though they claim to have automatic birthright citizenship. On top of it all, if you want to look at Mexico a little bit more, they have a very different situation from us. If you are born here in the U.S., you could grow up to be president of the United States. Not so in Mexico. You'll never grow up to be president of Mexico because their constitution requires that not only are you born in Mexico, but that your parents, or at least one of your parents, is as well. So there's still a second-class status for a lot of folks in these other countries. But the global trend certainly is moving away from automatic birthright citizenship. Many of the countries which once had them have ended it in recent decades. The UK ended it in 1983, Australia in 1986, India in 87, Malta in 89. Ireland ended the practice through a national referendum in 2004, and their biggest concern was birth tourism, people coming there to game the system. New Zealand in 2006, the Dominican Republic ended it in January 2010, and I think that it's important for Congress to provide some sort of clarification on this issue. There's plenary power issues here. This is something that's not just for the courts to decide. The political branches do have a say in immigration.
I'm out of time, but I promised Mr. Cohen that he would be able to address it. If you have any insight into, and again, I'm not often quick to cite what other countries are doing, but if you have any insight into why the trend is going in that direction, I'd be happy for the committee to take it.
If I could also, just for a quick moment, speak to a point that Professor Eastman raised, the Elk case. That was written by Justice Gray, who also wrote the opinion in Wong Kim Ark. And Justice Gray said that the Elk opinion had no application outside of the Indian context. And I think that's very, very important, because much of the language that we use, or that Mr. Eastman and Professor Graglia use, is drawn from the context where congresspersons, senators were talking about Indians, which is a much different case. That's the first point I would make. In response to the other issue, I would agree with you that sometimes looking at foreign laws perhaps not the best thing to do. And I would also say that our Constitution, and I hope that America is exceptional in this regard, it embeds this egalitarian, this deeply egalitarian notion of all citizens being equal by virtue of being born here. And I just think that's such an important principle. And for those who want to shoulder the burden of changing it, they ought to shoulder it by pursuing a constitutional amendment, not by suggesting that they can do it in any other way.
Well, I apologize to my colleagues for going over, and I'm sure that Mr. King will rectify that as we switch spots, and he recognizes my friend from California.
Thank you, sir.
Chair would recognize Ranking Member of the Immigration Subcommittee, Ms. Lofgren, for 5 minutes.
Thank you. In your written testimony, Professor Graglia, you say that the 2 dissenting justices in the Wong Kim Ark case quote, argued correctly that the rule-making locality of birth, the criterion for citizenship, is based on ancient English law and did not survive the American Revolution. I was interested today when I opened up the Politico online. There's an article, and they have, what happened on this day. And what happened on this day in 1789 was the very first contested election in the history of the House of Representatives. The House Committee on Elections rejected a challenge to William Lawton Smith's eligibility to represent Charleston, South Carolina. The challenge brought by David Ramsey was based on the fact that Smith could not satisfy the Constitution's 7-year citizenship requirement for serving in the House. Now, in Smith's defense, James Madison himself argued, and this is a direct quote, "It is an established maxim that birth is the criterion of allegiance." Mr. Smith founds his claims upon his birthright. His ancestors were among the first settlers of South Carolina. Mr. Smith was seated and allowed to serve, and I would ask unanimous consent to put that very interesting article into the record.
Without objection, so ordered.
In reading the testimony, Mr. Graglia, I think that you believe Wong Kim Ark was incorrectly decided 117 years ago. Would that be a fair statement of your belief on that case?
You're asking me, do I think Wong Kim Ark was incorrectly decided? As I said, yes, I do.
Okay. What about Plyler versus Doe that guaranteed the undocumented children to a right to public education? Do you think that was wrongly decided as well?
Plyler v. Dark?
Yeah.
Yes, I do. You see, I take
I
take a very limited view of the power of
I-
the Supreme Court. I think that these
Right.
decisions.
In reading through some of your other writings, I thought I saw that you believed that Brown versus Board of Education, that declared separate but equal educational facilities weren't equal, was also wrongly decided. Is that correct?
No.
Okay, well, I'm glad to clarify that. I think that it's important to not only listen to what our witnesses say, but to consider the source. And so I did do some reading and came across this in the New York Times. Professor Graglia himself has stirred up plenty of controversy before, they stated in their 1997 article. In 1986, he was considered a finalist for a spot on the Federal Appeals Court, but later affirmed the Hopwood decision. But the Reagan administration backed away from his nomination after a controversy over his use of the word, quote, pickaninny in the classroom and his apparent urging of Austin residents to defy a court-ordered busing plan. I would ask unanimous consent, Mr. Chairman, to put this New York Times article in the record. And now I would turn to Mr. Cohen. You have read the statements of all of the other witnesses. Would you care to comment or react to any of those statements?
I would, thank you. As Professor Graglia pointed out or acknowledged, he believes that the Wong Kim Ark decision was wrong. I think that's akin to walking into the machine guns at this point in time. Professor Eastman, I think, has a more heroic explanation to try to defend the case, but ultimately one that is equally unsuccessful. Professor Eastman argues that Wong Kim Ark's family tried to become as subject to the jurisdiction of the country as they could. But his argument is that it requires complete jurisdiction, and he acknowledges that the family in Wong Kim Ark did not have complete jurisdiction in the sense that he uses the term. So I think the argument is contradictory. The other point I would make about both of their testimonies is that they quote Mr. Trumbull and Mr. Howard, two senators, with words like allegiance, complete understanding, that kind of complete jurisdiction. And again, as I indicated earlier, All of those references come from the very unique context of Indians, and I don't think it has no applicability here. Finally, I think they both rely very heavily on the language of the 1866 Act, not subject to any foreign jurisdiction. And the language of the 14th Amendment is quite different. It was passed or came out of a different committee, and it was drafted by different persons. And the Wong Kim Ark case makes it clear that that language was in the 14th Amendment was intended to be broader. So those would be the basic differences I have with their testimony.
Thank you, Mr. Chairman. My time has expired, and I yield back.
Thank you.
You know, I might say that I think my position on Brown has very little to do with this, and you're bringing up things like that in this alleged mistaken pickaninny is in the nature of a slur. I don't know why you're bringing up these insulting things that has nothing to do with what I'm testing for here.
Mr. Chairman, I would ask unanimous consent to be granted a minute to engage Mr. Gragley to explain why.
Hearing an objection, the gentleman has been heard and we'll yield the 5 minutes to the gentleman from Idaho, Mr. Labrador.
Thank you, Mr. Chairman. Mr. Cohen, this is a really interesting issue for me, and maybe I'm going back to my law school years because I'm hearing good arguments on all sides. I've long been a defender of the 14th Amendment and birthright citizenship, but I'm hearing some issues that need to be addressed by Congress and need to be addressed in some way. So I'm seeing this as two separate questions that we need to address today. First is the policy of birthright citizenship the right policy for the United States? Second, actually 3 questions. Second, was that policy inherent in the 14th Amendment when it was first passed? And third, if we decide that it's not the right policy, how do we change it? Do we need an actual constitutional amendment, or can we do that through statute? So as I listened to all the arguments, I heard, I think it was Dr. Eastman say that at the time of the 14th Amendment, there was no illegal immigration in the United States. Is that correct?
Yes.
So don't you think that makes your argument a little bit invalid, that the 14th Amendment actually grants birthright citizenship to the children of people that are here without documentation?
I do not, and I can explain.
Please.
Okay. If you look at the era that Wong Kim Ark was decided, there's no illegal or...
But let me stop you there, because
Sure.
I agree with you that the Supreme Court decided the issue with regards to the children of legal permanent residents. I agree with you, and I disagree actually with Mr. Graglia that it was incorrectly decided, or at least I believe it's the law of the land at this time, and I'm not going to make an argument about that. But it did not decide whether the children of undocumented aliens are granted birthright citizenship. Would you at least agree with me on that?
Well, I would try to make 2 points, and because I grew up in Richmond, I speak very slowly. So give me a.
Me too. I grew up in Puerto Rico, and I speak English as my second language.
Okay,
and sometimes
we're
I
even
speak
then.
slowly as well.
The point I was trying to make about Wong Kim Ark is that there was neither legal nor illegal immigration at the time. But what we do know is Wong Kim's parents weren't eligible for citizenship. That was their stain. Right.
So we know they were not eligible, but we do know that they entered legally. They attained their legal.
There was no legal or illegal
Correct.
about it.
So there was no illegality about any of their actions.
But the point is that their disability was the fact that they could not become citizens. In that era, I would argue that was analogous to being illegal. The second point I would make is,
I just don't agree with that. I don't think you can analogize going through the process and not going through the process as the same thing.
Well, there was no process. That's my point. And the second...
There's always a process, sir. You became a legal permanent resident by going through a process of legal... I was an immigration lawyer.
But I was just saying then. In
But then
1866, there was not. That's
they
the
didn't
point.
just become legal permanent residents by just showing up. They actually had to go to a naturalization center. They had to go through the process.
There
of
was
legal.
no legal or illegal immigration.
So
in
just being in the United
1866.
States was sufficient?
Well, it was.
Are you sure about that? I'm not sure that I am.
I believe that I am. The second point I would make was, the group of people who were perhaps most analogous to what we think of as illegal immigrants today would have been gypsies. They were described, in very harsh terms, pariahs on the land, described as trespassers wherever they go. To me, that's as close as one can get. And it was without question clear that the children of gypsies were intended to be children or intended to be citizens if they were born in this country. I think that is as close as one can possibly
But wasn't that
get.
pursuant to a treaty with China, though?
No, we're talking about gypsies.
Yeah, but
No, I don't believe it was. I believe that the debate in Congress between Senator Cowan and Senator Conness has no reference to that whatsoever. And the court in Wong Kim made that same point.
Dr. Eastman, this is what I'm having a hard time with, because again, I may actually disagree with you on this issue, but I really find it interesting that there was no illegal immigration when the 14th Amendment came into being. And to extrapolate from that today it means that if you're the child of an undocumented alien, that you are then therefore an illegal a citizen of the United States, I don't see how you can do that. Can you?
I agree with you, Congressman, and the point of the Indian exchange is because that was where the question of your sovereign allegiance was risen. Indian tribes were domestic sovereigns. They were domestic dependent sovereigns. And so if that was not sufficient, they owed ultimate allegiance through their tribe to the United States, and that was held not to be sufficient to confer automatic citizenship, then almost by definition, somebody who doesn't even have that intermediate connection to allegiance to the United States would not be covered by the 14th Amendment. That's why that discussion is so relevant. And this exchange about gypsies, I want to real clarify. Senator Cohen thought that it would not apply to gypsies. When he's talking about their trespassers, he's not talking about them being trespassing in the United States. He's talking about them trespassing on private land wherever they go. And the answer was, of course, their children are going to be citizens because they are here lawfully otherwise, and they owe allegiance to the United States. Senator Cohen said, if a traveler comes here,
So the parents were here legally.
that's right. And he says if a traveler comes here, he gets the protection of our laws. That's the partial territorial jurisdiction, of which Mr. Cohen claims is what the phrase means. Senator Conus responds, I fail to see how that has anything to do with our 14th Amendment discussion, because we're not talking about territorial jurisdiction, we're talking about the allegiance-owing jurisdiction, and of course if they're here lawfully, they owe the allegiance. That was the key for them. And so when you introduce a group of people who do not have that allegiance, by virtue of the fact that there's no consent that they be here, that they are here unlawfully, that clause in the Constitution simply doesn't mean that they have automatic citizenship.
Thank you. My time has expired.
The gentleman's time has expired. The chair will recognize the gentleman from Illinois, Mr. Gutierrez, for 5 minutes.
Thank you very much. Mr. Greglia, I'd like to ask you, in 2012, you made some comments that raised a lot of eyebrows, explaining why you feel African-American students are not competitive in college admissions. You told a BBC reporter, I quote, I can hardly imagine a less beneficial or more deleterious experience than to be raised by a single parent, usually a female, uneducated, and without a lot of money. Things turned personal when the reporter told you that since he was black and was raised in a single-parent family, you are saying that he's less, quote, likely not as smart as a white person of the same age. In response, you said, well, quote, well, from listening to you and knowing what you are and what you've done, I'd say you're rather more smart. My guess would be that you are above usual smartness for whites, to say nothing of blacks. Can you explain to us that comment?
I don't understand what this line of questioning, like Representative Lofgren's, has to do with it. Seems to be some kind of a sleazy, underhanded move is being made here. Those are difficult questions.
You don't want to explain this to us? You don't want to explain this?
Excuse me?
You don't want to explain this?
I'm sorry. Give me the
You don't want to explain your comments?
comment.
Yeah, the comments that you made to the journalist from the BBC.
Explain which.
My guess would be that you, referring to the journalist from the BBC, are above usual smartness for whites, to say nothing of blacks.
I'm not sure I understand that, or that I'm not sure I made the comment.
Oh, you made the
I'm not
comment.
sure I heard the question.
You made the comment. Well, clearly, I think it is very important when people are raising issues about changing the Constitution of the United States and saying that their motivation is one. I think it is very clear to raise issues and statements that they've made in the past, especially when it comes to issues such as this. But since you don't want to speak about it, I'll let it go.
If I can explain the comment, I have never made a comment that in any way implied the inferiority of any group to other groups. Now, I did say that, sometimes it's very controversial that affirmative action is based on the proposition that other groups are not competitive, and to get into selective schools require preferences. Now, that just is a statement of fact, but it still is very controversial and very emotional. But it's got nothing to do with the quality of people, as I think you're implying.
Unanimous consent. It's titled "UT Law Professor Raises Pulses on Race and Admissions" by Rose Callahan in 40 Acres Special on December 12, 2012. So right around the corner. It was just 3 years ago. In 1997, Texas Monthly called UT's Lino Gaglia the most controversial law professor in America. This week, he's living up to the title by raising pulses with his comments in BBC radio interview on race and admissions. In the interview, Gaglia tells the BBC reporter that he believes African-American students can't compete in college admissions. Do you believe African-American students can't compete in college admissions?
No, I do not believe they can't compete. I do say the reason you have race preferences to selective institutions is that by equal competition, you get very few proportional representation. I'm explaining what affirmative action is about. That's what it's about.
I would like unanimous consent that it be put in the record. Chairman?
There's unanimous consent request to place the document into the record. Do I hear any objections?
Thank
I'd
you.
like to know the
I want to go to...
I'd like to know the nature of the document. Meanwhile, I'll reserve the right to object.
Sure.
Gentlemen reserve the
I'll
right
be
to
happy
object. Please proceed.
Pass that over to my colleague from Texas. I'd like to now go to Mr. Cohen for a moment. There are those that look at today's hearing and think that there's a relationship with today's hearing and the 13th and the 14th Amendment to the Constitution of the United States. How do you see today's hearing?
I am so sorry, but I could not hear you.
I'm sorry. There are those who believe that today's hearing has serious implications, historical implications, in relationships to the 13th Amendment to the Constitution and the 14th Amendment to the Constitution. How do you see the relationship of today's hearing vis-a-vis those two amendments to the Constitution?
Well, I think whenever we talk about amending the Constitution, it's something that we have to do so with great caution. The Constitution, since the enactment of the Bill of Rights simultaneously with the ratification of the Constitution, has only been amended 23 times in over 200 years. And so first, I think we have to have a darn good reason to do it. When we talk about amending our Constitution to take away some core rights that relate to equality and the egalitarian ethos that animates our country, I think we ought to be particularly concerned.
Thank you. And can you, how would I say this, weaken, abridge birthright citizenship without challenging the 14th Amendment to the Constitution of the United States?
No. It's clear, the court made clear in Walk Kim Ark that the only way that it could be done would be by constitutional amendment.
Okay. So really, what we're having here is a conversation that has to lead to a change in the Constitution of the United States.
I would agree if that's the course that the proponents want to take.
I guess we're going to have birthright citizenship for a long time. Thank you so much.
Thank you.
The gentleman yields back, and the chair would request if the gentleman from Texas would consider his reservation on the point of order.
Okay. Mr. Chairman, I'm going to withdraw my objection simply because Professor Graglia has already answered an editorial comment by a magazine writer and who offered no direct quotes by the professor. So I think the professor has already adequately answered any question about a non-germane subject to this hearing.
Since the gentleman from Texas withdrawn his reservation, the documents requested by the gentleman from Illinois will be entered into the record, and the chair will recognize the gentleman from Texas for 5 minutes.
Thank you, Mr. Chairman. One, I just want to point out this is a very significant hearing, and I think we all know that. Someone else has already mentioned that this is the first hearing on this important subject in 10 years. Also, I want to mention a recent Rasmussen poll which showed that a majority of the American people do not support automatic birth citizenship. And I think that is significant as well. We also have the trend among industrialized nations away from birth citizenship. There's only one other country now beside the United States that doesn't require at least one parent to be in the country legally. And I think that is a positive trend. Let me say that I feel that the only way you can justify saying that a constitutional amendment is required to clarify the 14th Amendment is if you ignore the Constitution itself, which gives the power to Congress to set immigration policy. You can only justify a constitutional amendment if you ignore the intent of the senator who introduced the 14th Amendment, who clearly said on the Senate floor at the time of debate on the 14th Amendment that it, quote, did not apply to foreigners. And I think you can only justify the constitutional amendment route if you erase the distinction between legal and illegal immigration, none of which I feel that you should do. And I just wanted to make sure that we have on the record that Dr. Eastman and Professor Graglia and Mr. Ferry all feel that we could clarify the 14th Amendment by statute alone. And presumably that would be challenged and then go to the Supreme Court. But to my knowledge, the issue at hand, birth citizenship, has never reached the Supreme Court and is likely to do so because of the standing problem only if a statute is passed by Congress. So I guess I have a twofold question. Do all three of you agree that we could clarify the 14th Amendment by statute? And do you feel that that's the only way we will actually resolve the issue, or is there another way for someone to get standing?
Representative Smith, I agree. And I will say this. If Mr. Cohen was correct that the 14th Amendment was clear, then the only way you could remove birthright citizenship would be by a constitutional amendment. The dispute here is whether that phrase subject to the jurisdiction is clear. And I think the legislative record, the early Supreme Court cases, make clear that it doesn't mean automatic birthright citizenship for everybody, but it's at least ambiguous. And Congress weighing in on what it understands that phrase to mean would be an important step. Wong Kim Ok clearly does not settle the question for the children of illegal immigrants. Neither does the footnote in Plyler versus Doe. And it's important to understand how high the floor that the Constitution set and how much it intruded on your power over naturalization when we adopted the 14th Amendment. Because the farther higher up we read that phrase, the less power the Congress has under its naturalization clause. And so there's a direct conflict here that needs to be sorted out.
And Professor Graglia, do you agree with that too?
I would like to say that the central question here obviously is, how should this jurisdictional clause be interpreted? I teach a course currently called statutory interpretation. And certainly a prime principle is you should never interpret or can't interpret a statute to reach an absurd result. And if the jurisdictional clause provides for birthright citizenship of illegal aliens, what you've done is you say you have a situation where on the one hand it's illegal to enter the country without permission, but what this law means that if you do it, you're a citizen. I would say that can't mean that. You know, as Justice Jackson said, if anyone makes an argument like that, the Constitution requires an absurd result, that can't be. And, you know, and bolstering that is what Professor Eastman said. The Constitution says you have to be born and jurisdiction. Born puts you under some jurisdiction. Yeah. So unless the jurisdictional clause is redundant, it has to add something.
Right. I agree. I think to allow the birth citizenship, by the way, I don't think we ought to say birthright. I don't think it's a right. I think it's just automatic birth citizenship. I think defies logic and defies common sense. Mr. Ferry, I think I have time for one more question, and that goes to the cost of birth citizenship. You've done some research on that issue, as I understand it, and give us an idea beyond what you have already as to the cost of government benefits as a result of a policy that seems to allow 10% of the births in the country to be to an illegal parent?
I mean, it's hard to measure costs. It depends on how you want to look at it. We do estimate, the Pew Hispanic Center also estimates that somewhere between 350,000 and 400,000 children are born to illegal immigrants every year. It's difficult to estimate how many birth tourists there are. We have a very rough estimate. It could be as high as 36,000 people per year as birth tourists. And of course, those do come with costs. You know, any type of cost that a person generates is going to be factored into this analysis. But for the example of children born to illegal immigrants, you know, we obviously as a nation, we provide them public education paid for by the taxpayer. And since per student expenditures in the United States are roughly about $10,000 per year, it's likely that somewhere around $13 billion goes towards the education of illegal immigrants in public schools. Now, if you're just looking at U.S.-born children of illegal immigrants, the cost is approximately $26 billion per year. And I don't think any Americans would say that we shouldn't try and educate those who are here in our country, but the reality is it does come with actual costs.
It does have a cost.
That don't really get addressed.
Thank you, Mr. Ferry. Thank you, Mr. Chairman.
The gentleman from Texas yields back, and the chair would recognize the gentlelady from Texas for 5 minutes, Ms. Sheila Jackson-Lee.
Thank you, Mr. King. Thank you for presiding at this time. Let me thank the ranking member for her presence and leadership on these very important issues. First of all, let me welcome Mr. Cohen. We've spent a lot of good time together. Thank you for enormous leadership on any number of important issues.
Thank
you know, I have a question for the professor, and I was just listening by way of my staff of the overall view of the gentlemen that are, I think, to your left or right, but are sitting alongside of you. And I thought I would pull out the 14th Amendment and read it as I had interpreted it, and it has not been contravened, I don't believe. And that is, and Ms. Cohen, you can just shake your head. I'm not going to come to you right now, but I wanted you to be prepared where I'm going, is that the 14th Amendment has the issue of naturalized. The 14th Amendment has the issue of, I'm not coming to you right now, but I'm laying sort of a groundwork for the question. The 14th Amendment has all persons born or naturalized in the United States and subject to the jurisdiction are citizens. But it goes on to say that individuals have due process rights. There is an argument at the table here as whether or not undocumented or visa holders are under the jurisdiction. I think that question fails to their loss, because we have due process rights, whether you are statused or not, and you are subject to police jurisdiction for sure, in the ability to be arrested for a variety of things beyond your status, or to press charges, or a number of things that are jurisdictional, and that you're subject to the jurisdiction of the laws of this land. But let me, I'll come to you, Ms. Cohen, just when you be prepared of what my thinking is. I wanted to raise this question with Professor Graglia. In the law review article that you attached to your testimony, you wrote that Wong King Ark's decision to adopt the English common law rule for citizenship argues against birthright citizenship for the children of undocumented immigrants. This follows, you said, from the Supreme Court's recognition that under common law, children of alien enemies born during and within their hostile occupation of a country do not obtain citizenship in the occupied country. Do you think a student who overstays his visa is an enemy of the United States? That's number one. When a mother who was previously deported re-enters a country unlawfully to join her husband and children, is she part of an invading army? Is she engaged in a hostile occupation of our land? Occasionally, we hear people refer to the act of illegal immigration as an invasion. John Tanton, who essentially founded the modern anti-immigrant movement, has a long history of racist and nativist remarks, wrote a book 20 years ago called The Immigration Invasion. Do you similarly believe that people who enter the country legally are, for all intents and purposes, invading our country? Did you get all three of those, Mr. Professor LaGregula?
I'm afraid I didn't get the question.
Do you think a student who overstays his visa is an enemy of the United States?
Do I think that a student who,
that overstays his visa is an enemy of the United States?
No, not necessarily enemy, by no means, no.
Do you think a mother who's coming back to be with her family and was deported, do you think that she is engaged in hostile occupation of the land?
Now, ma'am, why would I say a thing like that?
I appreciate you saying that you don't believe that. And then do you believe that individuals who come back into the country after being deported, who are seeking to be with their family, do you believe that they are invading our country?
You know, I don't understand the basis of these questions. The answer is no. That sounds like a silly thing.
I'm glad. I agree with you. It sounds very silly, and
Okay.
that's why I want to go to Mr.
Well,
Cohen.
I mean, I hope you're not implying I've said or implied any such thing.
I want to make the record clear that you don't believe that these are hostile invaders. May I go to Mr. Cohen, please?
I do not believe the hostile invaders. I'm very
Thank
clear
you,
about that.
Professor. Let me go to you, Mr. Cohen. You know the 14th Amendment is reminiscent of a bad history in the United States, one of slavery, and certainly we know this is the 150th year of the 13th Amendment. But how would you answer any legitimate reason or basis to take away a birthright from an individual born in the United States on the basis of the 14th Amendment and also our right to due process?
Well, I don't think an argument could be made from the current Constitution. The point that you made earlier is the point that a unanimous Supreme Court made in the Plyler case. Plyler was a 5-4 decision on the question of whether undocumented children were entitled to a free public education. But all 9 justices agreed that persons who were undocumented were within its jurisdiction for purposes of the Due Process and Equal Protection Clause. All 9 justices also agreed that that phrase, within its jurisdiction, would be interpreted in a predominant geographic sense, just as the term subject to the jurisdiction is in the first sentence of the 14th Amendment. That is exactly the same decision or interpretation that was given in the Wong Kim Ark case. So unless one does radical surgery on the 14th Amendment, I don't think that one could accommodate some of the views that we've heard here today.
So our Constitution then really supports the policy, which this question asks, is that citizenship birthright or the right policy? I can't answer it any other way, but yes.
It embodies it, yes.
I thank you. I thank the gentleman and yield back. Thank you very much.
The gentlelady from Texas has yielded back, and we're going to stick with the Texas theme and recognize the gentleman from Texas, Mr. Ratcliffe.
Thank you, Mr. Chairman. I'd like to thank the witnesses for being here today to talk about this very important issue. The 700,000 Texans that I have the opportunity to represent, like most Americans, are deeply concerned about the impacts of illegal immigration in this country. Before coming to Congress, I had the opportunity to serve many of these same constituents in my role as the United States Attorney for the Eastern District of Texas. Back in April of 2008, in that role, I arrested some 300 illegal aliens that had committed Social Security fraud and identity theft against hardworking Americans. Now, my actions in that regard were not a matter of choice. I had taken an oath to faithfully execute the laws of the United States. That, by the way, is the same oath that the President takes, to faithfully execute the laws of the United States. And so many of my constituents are frustrated with what they are seeing right now as a willful disregard for the rule of law in this country. And given that broader context, my constituents are concerned that the 14th Amendment that we're talking about today, the Citizenship Clause of the Constitution, is interpreted in a way that gives children of illegal aliens citizenship at birth. So many of the folks that I represent feel that the current policy encourages folks to come to the United States solely for that purpose. And there's ample evidence out there of this fact. Just back in March, the Wall Street Journal reported that federal agents had raided several sites in California that were connected to different multi-million-dollar birth tourism businesses or anchor baby businesses. And I think Mr. Eastman, I believe, or maybe Mr. Ferry, talked about the fact that this is an industry where maybe 350 to 400,000 children are being born to illegal immigrants in the United States, and that just really brings this issue into focus for so many. So I'd like to start, Dr. Eastman, with a question for you. I've understood your testimony to be here today, the same as Mr. Graglia and Mr. Ferry, that Congress does have, in your opinion, the ability to deal with this issue statutorily, as Mr. King would like to do, as opposed to requiring a constitutional amendment. Is that correct?
That is correct.
All right. So given that, I'd like to for you to comment on the importance, from your perspective, of Congress moving forward and settling this issue once and for all, and exercising its constitutionally provided power over naturalization.
Sure, and if I may incorporate an additional brief response to Representative Jackson Lee in that, because I think it's important to get beyond the gotcha game that's going on here. The reason even illegal immigrants are protected by the Due Process and Equal Protection Clauses is because those phrases use the word person, all persons. There's nobody that claims that they are equally protected by the Privileges and Immunities Clause, which applies only to citizens. The question for the Citizenship Clause is in which box illegal immigrants fall. Are they citizens entitled to all three protections in the 14th Amendment, or persons who are not citizens that get due process and equal protection rights as well? And it's my contention, and Professor Graglia's contention, that the subject to the Jurisdiction Clause raises an additional requirement than mere birth on U.S. soil. Clarifying that to what the floor of the Constitution actually requires is critically important so that you can address the policy questions on whether it makes any sense whatsoever to have limitations on immigration, and yet if you flout our laws, you get the holy grail of American citizenship. And I don't think the Constitution prevents you from addressing that fundamental policy question, and the notion that it does, I think, is absurd. And that's what we're trying to clarify here.
Thank you, Dr. Eastman. Mr. Cohen had testified earlier and talked about, and I'm quoting here, the principle of citizenship by birth is as old as this nation, and cited in connection with that an 1830 Supreme Court case, Inglis versus the trustees of Sailors Snug Harbor. Are you familiar with that case at all?
Yes, I am.
Okay, and so do you agree with Mr. Cohen's testimony?
No, I don't, and quite frankly, I'm stunned, and Representative Lofgren made the same error. The language that they're both quoting in his testimony and her opening statement is from the dissenting opinion in that case. The majority actually held that the individual was not a U.S. citizen, despite the fact that they were born in New York. Justice Story goes on to offer further explanation in his dissenting opinion, and he says this: to constitute a citizen, the party must be born not only within the territory, that's birth within the United States, but within the allegiance of the government. That's exactly the point I've been making about what the 14th Amendment requires.
Thank you, Dr. Eastman. Gentlemen, I appreciate all of you being here. I have questions for all of you, but they didn't give me enough time, so I will yield back.
Gentleman from Texas yields back, and the chair recognizes himself for 5 minutes. And I thank the witnesses for your testimony here today. I'm just recapping how this works to me. Two questions out there. One is the policy question, the other is the constitutional question. Now, if we could just take this to the policy question for a moment, and I'll just speak to that, that when I look around the world and I see countries that have a policy like this, and the list of countries that have a policy like this, the only one in the modern industrialized world that seems to retain this policy is Canada plus the United States. And the rest of them, I don't know if anybody has lined up in any long lines to get into those other countries that do have a birthright citizenship as part of their policy. I listened to representatives from the Dominican Republic talk about what's happening with Haiti being their neighbor and how they essentially analyzed their constitution and found a way to reverse that a few years ago to their benefit. And so I don't think I'm hearing an argument as to why it would be a good idea to grant automatic citizenship to any baby that could be born in the United States, to any mother who could find a way to get into the United States. That hands over the immigration policy to everybody except Americans. And so I don't know that that's even a debate before this committee unless you want to expand your political base by any means necessary. Second thing comes back to then is the constitutional question, which I was confident of when I walked in this room today, and I remain confident of that position. But the question to pose really is, how do we get the constitutional question answered? And the way to get the constitutional question answered is anybody going to litigate today? I don't think so. We have to have a statute in order to trigger that constitutional litigation. And as I examine through this, if that's the case, I don't know what's left out here to be answered by this committee or by the witnesses. If it's the majority opinion of this committee that it's not a good policy to grant automatic citizenship to any baby born on U.S. soil for any reason whatsoever, other than a couple of light exceptions, if it's not a good policy, then how do we get to a good policy to rescind and reverse this practice that has grown? And so I would turn to Mr. Cohen, and I wanted to ask you for the record, watching the president's policies on immigration that have emerged from the Oval Office, I presume, on DACA and DAPA and the Morton memos and these components that have put this country through this strife that we have. You've looked at those constitutionally, and I don't want to editorialize on those, but could you just give me kind of a yes or no or a general idea whether you believe that they are constitutionally founded?
You know, I don't feel confident to offer an opinion on that subject, quite frankly.
And that's fine. It wasn't a subject to come before this committee, and I appreciate that. I would just make the point that the president is making up immigration law as he goes. I don't think that there's a solid argument that the president has the authority to legislate. And Article 1 says all legislative powers herein shall be vested in a Congress of the United States, and that's the House and the Senate. And so that's the statutory part of this. But I would pose this to Mr. Eastman. On the same premise that the president asserts that he has a constitutional authority to, what I will call it, legislate an immigration power and grant a lawful presence, and I put that in quotes, to the DAPA recipients, the DACA recipients, and the others that are picked up in the Morton memos. On that premise, could not the next president of the United States end birthright citizenship based on the same rationale?
Well, I suppose based on the same rationale, I would hope the next president of the United States would take more seriously the obligations of the Constitution than I think this president has manifested on that precise issue. I don't think he has the constitutional authority to do that. And I'll go back to what I said before. If Mr. Cohen is right that the Constitution mandates birthright citizenship for everyone born in the United States, no matter what the circumstances, it would take a constitutional amendment to revise that. I believe he's wrong about that. I believe all the evidence strongly supports that he's wrong about that. That's the issue that remains open and that needs to be tested.
Thank you. And Mr. Fear, I didn't hear from you. If you go a little more broadly on the policy side of this and the effects of this society, is there a limitation that we could expect if this practice goes on and, say, the next Congress and the next president simply, or if there's a constitutional amendment that guarantees this birthright citizenship, can we confer citizenship on people that don't even want it? And what happens to the demographics of America if this policy is not reversed?
Well, one of my concerns is that this whole debate is the result of a phenomenon that's sort of happening without anyone at the helm. No one's really clear exactly when the first illegal immigrant was entered the country. No one's really clear as to when the first birth tourist came here. But the administration, some administration, decided to say, you know what, go ahead and give them a social security number, give them a U.S. passport, and it just sort of happened at some point, and no one really knows when. And I think Congress hasn't addressed the problem, and as a result of not addressing it, we rely on floor statements from 100 years ago. We're relying on a footnote from a Supreme Court case in 1982. I think some clarification on the issue from Congress would help a lot. And to the idea that Congress can't legislate on constitutional matters. One of the committee members, Congresswoman Jackson Lee, this session, I believe, has a bill that would narrow the scope of the Second Amendment. It would raise the gun ownership from 18 to 21, I believe. So she clearly believes that Congress has a role in interpreting and deciding the scope of constitutional amendments. And as I mentioned in the opening, Senator Harry Reid believes the same thing, or at least did at one point. So
we'll get that quote into the record. As my clock is ticking, Mr. Fear, so I'd like to just turn the last question to Mr. Cohen. And Mr. Cohen, you heard Mr. Graglia testify that the reward for committing the crime of unlawful entry into the reward for committing the crime of unlawful entry into the United States is conferring automatic citizenship on the child that you might give birth to in the United States. Can you give another example of a reward for law breaking, for committing a crime, specifically a crime, and a reward that's conferred in any aspect of U.S. law?
No, I can't, but the reward is not, or the penalty is not something that should be borne by the innocent child. That would be the argument I make. And I would say that argument is as old as the Bible.
In reclaiming my time, and I appreciate the gentleman's response, and I would say that if we had that same sentiment applied to the people who are locked up in our prisons, there wouldn't be anyone in our prisons. So I appreciate the testimony that we received today. It concludes today's hearings, and I want to thank all our witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is now adjourned.